Hello, my name is Matthew. I'm from the Nations of Sanity project, a project that's based on the assertion that crime and law can and should be defined by the concept of individual self-ownership and established as the terms of a peace agreement. And I've invited Stephan Kinsella to have a conversation today about that idea and also about his Universal Principles of Liberty document, as well as his addendum to that document that he's working on at the moment, and how his work and mine have a certain synergistic potential in my mind, and I'd like to kind of explore that more with you. So perhaps probably the best way to start this off, if that's okay with you, Stephan, is to hand over to you to just introduce the Universal Principles of Liberty document. So I'll put a link in the description for people so they can check it out. And sorry, I haven't properly introduced you to people, but obviously most people know who Stephan Kinsella is. He's a well-known author, libertarian thinker, former patent attorney, and a writer of many books, but also the writer of a document called the Universal Principles of Liberty. And yeah, sorry if I hand it over to you, Stephan. Thanks again for taking the time to have this conversation. And yeah, just tell us a little bit about this document.
All right. So as I was saying off air, so I've written a lot of things. Well, I spent years understanding liberty and economics, and then trying to write about my opinion about how to correct it and the right way to view things and how to extend it. That's what libertarian writers do. We discuss, we inquire, we learn, we talk, we develop. I think around 2022, I was at the Reno Libertarian Party convention, and I was a delegate. And that was the year that the Mises Caucus took over and made it temporarily a little bit more Austrian and radical. It's fallen to shit again. But anyway, at that convention, we were able to get added to their platform a more concise and more coherent statement of the general principle of what libertarianism is about, which was, and I wrote it in this, I think, plank 2.1 of the platform. And it basically defines what aggression is. And you can take a look at that. But that's basically a little code. It's a little abstract statement or concise statement of what we believe in. And basically, it's that we oppose aggression, but aggression is defined in terms of basically using someone's resource without their permission, or their property, what most people say. So then the second part is, well, then what's their property? The property is, so basically aggression is a dependent term that depends upon what our property rights are. So I just said property rights are basically the right to self-ownership, which is the defeasible or the default presumption of self-ownership. You own your body. That's what it means to say that murder is aggression, or murder is a crime, or murder is a rights violation. That's what self-ownership means. They mean the same thing. So owning my body is the same thing as saying using it without my permission, or killing it, or committing a murder or battery, or is wrong. So they're two sides of the same coin. So the first part is self-ownership or body ownership, which is a presumption, but it could be defeated. In other words, you could overcome it if someone commits an act of aggression. When you commit an act of aggression, you then make it permissible for someone to use your body without your consent because they need to defend themselves against you. Okay, so that's the first part. And the second part is ownership of previously unowned external resources, which people call property, which I don't call property because it's the wrong way to use the term. But anyway, it's an owned resource. And you determine ownership of resources by the first use principle, which is homesteading or occupation. And then, or by contractual transfer. If you transfer the resource to someone by contract, then they're the owner. So those three principles, and one other subsidiary principle of rectification. If you commit a tort against someone or you harm them, you might have to transfer some resources to them for compensation. But those four principles, self-ownership, homesteading, contract, and rectification, those are the core principles of what I think libertarian principles are. And I stated them in a concise form. And then I started thinking, we need to have a more elaborate version of this, which is what the Universal Principles of Liberty became. And it came that way because years ago, maybe 10, 15 years ago, I was consulted to help draft an earlier version of the Liberland Constitution. And it turned to a committee project with other people, and it got out of hand. I didn't like the way it turned out for two reasons. Number one, there was too many cooks in the kitchen. And then there was other impulses by Witt, the president. They wanted to appeal to the community, and they wanted to start a state. So when they said libertarian constitution, they were thinking, take the U.S. Constitution, but do it better, make it more libertarian. But still, it was a document setting up a state. And I'm an anarchist, so I'm like, how can you have libertarian principles in a document that's setting up an organization that violates rights? So I kind of withdrew from the project. And now, coincidentally, you're going to talk about the possible use of the principles, which I wrote recently, in maybe the Nations of Sanity or in others. I did go to the Liberland Christmas party just last year, and they decided to incorporate into the Liberland Constitution a clause saying that to the extent that there is ambiguity or the need to do gap filling, then resort could be had to the the universal principles of liberty. So it wouldn't override the statist parts of it, but at least it's there as sort of like a nudge or a hint, like if you could try to interpret this document in line with the universal principle of liberty. Anyway, I was approached by a guy named Max, Free Max we call him, because he had a competing project, which I don't want to go into in detail because it's not public yet, but it's another unowned area on the earth. It's a big territory, which is mostly uninhabited, but it is habitable, unlike Antarctica or something. It's somewhere in Africa. And he wanted to try to make that into a free society, but he wanted to lay down the rules, not a constitution, which means to constitute or make up a state, which is what the Liberland Constitution is, but just to lay down the principles everyone aspires to agree to that govern the interactions of the people, the law of this area. So he finally motivated me to finally put down on paper my principles for the purposes of his project, but it just was an excuse for me to do it. So what I did was I tried to take those principles I put in the Libertarian Party platform and make them a little bit more detailed and elaborate. But I stopped short of writing on things that there is disagreement on or uncertainty among libertarians. Like I didn't address abortion because that's controversial. I didn't talk about immigration. Also, I didn't talk about particular things because my study of the Roman law in law school and my understanding of the way legislation is one form of law in today's legal systems is that you have these codes like a constitution, like a state constitution in the US or the American Constitution, or a civil code in Europe or in Louisiana, my home state, which is like a codification of the private law, which was organically developed by the common law in England or by the Roman law in Rome or customary law in Europe. Those are seen as sort of special codifications of law. And like, for example, the Constitution in the US requires a very elaborate procedure to amend it. You can't just amend it like regular legislation. And it's more abstract and it's more aspirational, like the Declaration of Independence is. And a lot of it goes back to the Magna Carta principles and common law principles. So it's sort of, they're infused with a little bit higher level of respect than just your average mundane legislation, which the legislature can just make up any day that they want to. The point is, in a constitution, you shouldn't have particular laws in the Constitution. It should be more abstract. It should have the framework that other laws are held up to, or that govern the procedures by which other laws are developed. But the procedure, and Randy Barnett in his book, The Structure of Liberty, talks about this, the difference between what he calls abstract principles and legal precepts or concrete legal rules. So any legal system that's functioning and working has a series of day-to-day rules that develop over time. And hopefully, if they're just, they're compliant with a more basic set of principles. So that's the way I was looking at it. Like the basic libertarian principles like non-aggression and property rights in your body, those are general and kind of abstract. But to have operational day-to-day guidance, you're going to need in society a functional legal code. So I wanted to write a more abstract series, explication of libertarian principles, but also to avoid areas in which there's strong disagreement or that it's not settled yet. So that's what the universal principles of liberty are. Like, for example, it says in general that a person which has a certain rational capacity has rights. But I didn't specify whether that covers only humans or whether it would cover robots or space aliens or dolphins or children of, or fetuses. I didn't, it was more abstract. In those principles, I contemplated that they would be like the foundational set of principles that a legal system that grows from that, thinking of how the Roman law and the common law grew, would consult and would be built upon. So I contemplated in there that in any legal system, and I'm contemplating that it's not adopted by legislation, these principles, like the Libertarian Constitution would be, and it's not legislated. It's just it's what people largely believe, and this is the codification of the principles widely shared in a free society. But I contemplated in there that over time you would have a more developed body of law, which you could call them secondary rules or concrete rules or legal precepts. And some of those could form from custom. They could form from negotiation, from arbitration. They could form from case law. They could form from agreements. Like you could have a community, like Hans Hoppe's covenant community idea. You could imagine a region where people say, we're all entering this area, or a homeowners association, something like that, where people agree that, okay, we agree with the basic principles, but here's in this community, you have to, I don't know, be Christian or something, or otherwise you just have to leave, something like that. And as you've talked about, and I think you've talked about with Mark Victor, with his Live and Let Live project, there's some understanding on everyone's part that there are gray areas. There are areas where we should stay out of. There's areas where it's sort of it's discretionary about how you implement a certain rule. Like you might have, I don't know, let's say you might have the understanding that women of a certain physical maturity can consent to sex in one community, but it might be higher in another, but it's still within a certain range that's kind of reasonable, something like that. So I was envisioning that this code would be supplemented with a concrete set of laws and also with comments from commentators. So I contemplated that happening, and now I'm doing it. So what I'm writing is two things. I'm writing annotations, which is, as the drafter of the document, I'm writing comments about how it was drafted, and with footnotes saying, okay, this clause here, if you want more information on that, go see this article or this book. It's just like when you have a civil code or legislation in England or in an American state, you often have the statute, but you have legislative comments, and they're not part of the law, but they can help inform the court interpreting the law if it's ambiguous. So my purpose there was pedagogical and educational, and that's what I'm going to do. Second, I'm going to do that next. The first thing I'm going to do is the other thing. So I'm going to write my annotations, which is as a drafter of the code, and I'm like the main drafter, but a few other libertarians like Max and Alessandro Fusillo and two other lawyers helped me on it, but I'm the main guy behind it. But I'm going to write Kinsella's annotations on the code, just as like if you want more detail. I didn't want to put that in there because I didn't want it to be part of the code. So you have the bare code. It is what it is, and it says what it says. But then, I might have footnote 12 for more elaboration on this point. See articles A, B, and C. And they might be ones that agree and disagree, but it'll just be for further reading, basically. But then I'm going to write the supplemental principles, which I think I personally, as Kinsella, believe follow from that, but not every libertarian does. So I'm going to go into more detail there. Now, I did put intellectual property in there, at least in bare terms, because I think that even though there's disagreement, I think they're so wrong that I was okay putting that in there. But I might put in there some open borders immigration stuff that some people disagree with. I might put in there abortion. I'll put my view. So that would be Kinsella's secondary. So then you could imagine a community that adopts the universal principles of liberty as its foundational law, but also adopts Kinsella's supplemental principles. Or it might adopt Matt Sand's supplemental principles. You could see different flavors in different communities doing that. That's how I'm envisioning this. And I know, by the way, all of the statist lawyers in the world would say this is impractical. You have to have a government, but that's because they believe in a government. They can't imagine anything happening organically and by voluntary consent anyway. So that's what I'm doing. So In the secondary principles, supplemental principles, I'm going to go in and flesh it out a little bit more. But even if you combine the universal principles with my annotations and with my secondary principles, it's still not going to be a full-fledged legal code. That would be taking these things together and having courts in a free society start arbitrating disputes and gradually forming an applied law, which would be like a customary or a case law or just a secondary overlay of law, which would be viewed as like, so there's three parts of the law. If you ask a guy on the street in this free society what the law is, he would say, well, you have the principles, which is like the Constitution. And then you have the supplemental principles, which our community has adopted, Kinsella supplemental. And then you have all the case law that's developed and the comments by commentators and treatises that have grown up since then. So that's how I envision it. And the reason that final part is, like, if someone said, okay, Kinsella, you've done with number 1, you've done with number 2 and number 3. Now why don't you write like a full-fledged civil code? So what I could do is I could take like the Louisiana Civil Code, because it's in English and it's pretty elegant, and it's basically a nice, elegant codification of Roman private law principles, which are largely consistent with my general principles. So I could just take the Louisiana Civil Code and I could just edit it and take out the bad parts and reform the others, which is what you have Judge Narragansett doing in the final part of Atlas Shrugged, when, you know, Galt's Gulch, utopia is kind of starting to be achieved, and you have Judge Narragansett sitting by himself, and he's taking an ancient document, which is the U.S. Constitution, and he's striking out, like he's slightly tweaking it, because of course Ayn Rand viewed the U.S. system as almost perfect, but it needed a few adjustments. So you could imagine some anarcho-capitalist libertarians saying, Kinsella, why don't you or some committee of guys, why don't you write your own legal system? But to me, that would be like Esperanto. It'd be like, why don't you design your own language? I mean, if you understand how law develops, it has to develop organically. It can be based upon intuitive or basic principles, and they could be like a recursive process. They could be like, you might start out with a kind of a rough formulation of your principles, like don't harm people, leave people alone. But then over time, you realize that's not precise enough, because there might come a dispute where that general formulation is not enough, and the judge has to make a decision. And when he does that, he makes a decision, and then people can criticize it as wrong or right. But then it would help the theorists go back and refine their own abstract principles. And I think that's what I've done. And that's what I think we're at the point now, 70 years into modern libertarianism, where I think it was time to do my universal principles. It was right. It was a good time to do it. We didn't have to wait any longer to get that done. And I won't say they're perfect, but I think I thought about this for so long, and I really think there's, like, it's been a year since then. There's nothing I would have changed in it, really. So I'm pretty happy with it. I guess you could imagine someone else doing, because it's open source, someone could come up with, Matt Sand's augment or Universal Principles of Liberty Part 2B or something. And then if someone wants to adopt it, they could. But I'm really happy with it. But to say some legal genius like me or whoever, a new Rothbard, whatever, should sit down and take these principles and let's go on and write the legal system. Well, it's number one, it's premature because we don't need it yet. Because, okay, let's say I write it. It's like a Dungeons and Dragons game, or it's like a new language no one speaks. I can write it, but then what are we going to do with it? Like, there's no free societies on the earth yet to do it. And number two, that's just not how law would be formed. Even if we got this Liberland or some new anarchist territory to adopt it in general, then you would have to wait and see how it develops based upon the realities of the situation, the context, the customs that arise. You just couldn't predict it ahead of time. So it's premature for two reasons. There's an inability for any one person to do it. Like I've written, there's a limit to armchair theorizing. And one limit is that that's not how law develops. And the other limit is that hypothetical cases are almost never fully specified. So, for example, you have this famous case, the flagpole example. Libertarians debate this shit in their dorm rooms late at night or at libertarian meeting. I've done it myself. They'll say, okay, if someone falls off of a flagpole on the apartment above you, and they catch onto, they fall off a balcony on their apartment, and they're plummeting to their death, but they grab onto your flagpole, which is your property, and they're knocking on the window, they want you to let them in. Otherwise, they're going to drop and fall to their death. Do you have to let them in? Do you have a positive obligation to let them in, or can they come in? Or do you have the right to just say, die? I don't have to help you at all. And these are interesting questions. And I think there's some intuitive answers, but the problem with it is it's without context. Like, it depends. What if there's an agreement by the landlord saying that in emergency cases, you have to let someone in? You know, I mean, and in a real case, in the real system, in like the way the common law formed and the way the Roman law formed, there was real cases by real parties between the court complaining about something and having a dispute over a given resource. And they asked the judge for relief, and the judge could ask questions. They could say, they could have witnesses, they could have evidence, they could ask what the customs were, so they could fill in this context and make a more informed decision, which you just can't do in a little stupid hypothetical. It's like the button pushing hypothetical. People say, if you could, like Rothbard, if you could push one button and abolish the Federal Reserve, would you do it? There's no clear answer to that question, because the question is by what means, right? Because if the means is killing half the people on the earth, or you know, it's like the AI paperclip thing. Or if you gave this robot the instruction, make as many paperclips as you can, or make a bunch of paperclips, it might kill every human on the earth to do it. It might be a runaway problem. So the point is, you can't answer these questions without specifying the means, and that's how law has to be formed, I believe. Now, interestingly, in the Roman law, there was the rare exceptional case where these very smart jurists who had studied the Roman law for hundreds of years, and they would gradually refine it by commenting on it, and that's how the way the law developed. Every now and then, they would entertain hypothetical questions. They would say, okay, if A and B do this, what would be the result there? And then they would come up with an answer. But even then, it was sort of like a hypothetical what if, and then it might be relied upon later, but it was still limited to a heavily context-rich system. So that's my personal view, is that there's a limit to how much we can do from our armchairs, and in any way it's premature. But I think if I can develop my secondary principles and my annotations, then we have a core starting point for people to at least have a starting point to talk about. It illustrates what the core principles would be if you flesh them out. Anyway.
Yeah, I mean, with the hypotheticals, I feel like, they're very useful for us when we're kind of testing the principle and kind of getting a better understanding of the principle, saying, okay, well, how would it apply in this circumstance and that circumstance? Yes. But like you say, it doesn't cover all real world situations, because the real life is much messier than the little hypotheticals that we make up in our head just to test a certain aspect of the principle, or to illustrate a certain aspect of the principle. So no, I fully understand that. There's quite a lot I want to speak about. One of the things I wanted to pick up on as well, because you mentioned about, like, obviously, I understand the reasons why you omitted the areas where there was a lot of disagreement, but then you're obviously going into them with your kind of supplementary work is obviously going to then kind of delve into some of these areas where there is disagreement. And one of the things I think is quite an important point to make with that, and why I think that supplement is very important, is even though there's a lot of areas where there's disagreement, I don't think that's the same as grey areas necessarily. Like, there are a lot of grey areas where there's disagreement, but there's also a lot of areas that aren't really grey areas, but there is disagreement, because that's true.
There is a distinction, and I think that's important to make that distinction. I don't know how you articulate it, but there is a distinction between grey areas and areas of disagreement and uncertainty. I mean, there is different distinctions about what types of problems we face when we face these issues.
Well, IP is a good example of that. That's an area where a lot of libertarians disagree, but it's not a grey area. The pro-IP libertarians are just wrong. I don't want to sound arrogant saying that, but they are, when you kind of explore the kind of property rights and first use principles and all of these things, and the whole fact that copying isn't stealing. And there's a lot of linguistic trickery that I think a lot of libertarians kind of fall prey to when they get on the pro-IP side of things. Like it's just because it's called property, they immediately think of it as property in their head, or the fact that when they talk about stealing ideas, that's, like I say, that's a bit of linguistic trickery, because you're actually just copying. You're not stealing. If you steal, you're taking it away from someone. When you're copying, they still have
That's why I put intellectual property in there, even though some people disagree, is because it's such an obvious implication of the only way to coherently state the libertarian principles. Like that, to not say it, even if you didn't say it, it's implied. It's implied. Once you say that you have a property right in your body and you have a property right in scarce resources that you homestead or you acquire by contract, that just doesn't leave any room for intellectual property if you understand what intellectual property rights are. So I'm just spelling out what's implied in a coherent restatement of abstract libertarian principles in the first place. But for example, in my supplemental principles, I'm going to explain in more detail what and why threats and fraud and maybe things like stalking and things like that, why and how they should be considered. And also maybe in one of those documents, things like the difference between criminal law and restitution, or the standard and burden of proof, like and also the difference in like proportionality as it applies to self-defense and to retaliation after the fact. Like all those things are interesting, but they just didn't need to go in there. And I think some of those are more controversial and some of them are less controversial. And some of them are more gray area and some of them are not gray area. They're just controversial. So there are these interesting distinctions there.
Yeah, and I think it's important that we separate, or do the best we can to separate, the areas where there's just a lot of disagreement and the areas that are genuinely kind of grey area, situations where there's like a genuine, even with the principles behind us and interpreting them properly, there is still fuzzy edges. That's just the nature of things. I mean, I think I've spoken to you before about how in my own article I used the example of the desert and the grassland and the area in between, and I kind of use the desert as a metaphor for obvious non-aggression principle violations and the grassland as an example of obviously just exercising your self-ownership. And then there's the area in between where one slowly becomes the other, and there's like features of both. It may be arid, but there might be a few spots of grass, and that's I kind of liken that to the whole grey areas with principles. That's why we kind of I like the abortion thing's a perfect example, because some people say, well, what about the self-ownership of the mother and her bodily autonomy? Right. And other people rightly point out, well, yeah, but that she has a other self-owning individual inside her who, and her self-ownership doesn't give her the right to kill necessarily. And then, I mean, in my opinion, the abortion thing really becomes a point of really defining when we have a sentient being that's entitled to rights. And a lot of the stuff around the abortion debate is kind of missing the point, because like for example, the self-ownership of the mother is perfectly granted, but that doesn't give her the right to kill her children. So it's really about whether it is just her body. Like for example, I think it's hard to argue scientifically to protect the baby back to conception, because at point of conception it is just cells, and the mother could say, well, it is my body, and there is, it may well develop into a sentient being with rights, but at the moment it's definitely not. But I think but on the other side of it, it's also fair to say that becomes a sentient being long before it's born. You know what I mean? So there's a kind of, I feel like there's a validity to protecting the baby before birth, because there's nothing magical about birth that suddenly makes it more sentient or more conscious or more kind of entitled to rights. But you could argue that entitlement to right doesn't go all the way back to conception. So there's like a genuine grey area there, but there's not necessarily a genuine grey area over the mother's self-ownership giving her the right to kill a baby.
I think that, so there's, I think that when you have, I think it's permissible to have nuanced, more layered, higher level considerations when these things get trickier, because like you could take into account the reality of the world, which is that the way legal systems work, the nature of dependency, and the fact that legal systems, like it's kind of an Ayn Rand point, but legal systems have to basically be established and formed among the self-sufficient, healthy, non-psychopath humans. Like it has to be at least work for them. But then if you have like extremely helpless and dependent people, like, I don't know, someone in a coma or a fetus, even if you say they have rights, the fact is they are dependent upon the protection of those rights and the recognition of those rights by the healthy, functional people. So that does change the analysis a little bit. And also, if you realize that a legal system is adopted practically for a function, that is, it's to help us live together better than we could live without norms and without values and without laws. Because you can live in society with no norms at all. It's just you're always at threat of violence and theft. But so the whole purpose of a legal system is to add a normative layer on top of the natural acts of using your body and using resources. Like the whole purpose of a legal system is to provide a normative communal support for the idea that we should try to avoid interpersonal conflict and violence by resorting to these norms that are widely shared. Like that's the general high level view. And once you see that, then you realize also that any working legal system is going to have costs as well as benefits. But the cost would be the fact that we're infallible and the fact that there's specialization, so that any agency, even if it's an anarchistic system, there's always a danger of abuse and corruption by the law enforcers, right? There's favoritism, and then there's fallibility, and there's the possibility of mistake. So those considerations would go into, like, if you have an institutional, like if you have a rule that says self-defense is permissible, like if you have to act as your own judge, which is usually frowned upon in law, but if you have no choice, you can use self-defense. You have to be your own judge. You have to defend yourself. But that right is heavily restricted, because if you let someone go out and become a vigilante and just enforcing the law when they feel like it because they have the right to, there's a danger of being biased in your own favor. There's a danger of overpunishment. There's a danger of not even signaling to the community who's in the right. If you see one guy taking a wallet from another guy, you don't know if it's a robber or if it's someone retrieving his wallet. Okay? So these rules develop that they allow some emergency action, but if you have the ability to invoke the community to like go to trial, that's going to be favored. And if you don't do that, you're going to be seen as dangerous and an outlaw, and you're going to pay ostracism costs or higher insurance costs or something like that. So you can see all these things play together. But what I'm saying is, if you realize all these things and you say that we realize that if we make murder illegal, that's just the legal analog of self-defense, basically. Okay, and the fact that it's possible for the court to convict and punish someone who's actually innocent is not going to keep us from having a legal system, because the only alternative to that is complete chaos. I won't say anarchy, but chaos. So we're willing to pay the price of some mistakes that's a result of our infallibility and our lack of omniscience, because there's no other alternative. But we're at least aware of that, which would lead us to say, well, if you have an institutional criminal justice system, restitution should be favored over punishment. Even if you technically have a right to punish, the fact that you might be wrong, because we know there's a possibility of mistake, means that we favor restitution as opposed to actual retaliation and punishment, which doesn't infringe the right to self-defense in the moment. But after the fact, if we have a nice working institutional system with courts and law and arbitration and insurance companies and jurors and all that, it's probably going to be better to have a restitution-based system rather than a punishment system. And by the same token, even if we say that we're going to have a system where you can try someone accused of like theft or rape or murder, even with the possibility of a mistake, we might say that, yeah, but if you actually make abortion illegal, even if we grant that a late-term fetus has rights, that kind of policeman and legal system would result in such an intrusion onto the family affairs and matters that it's not feasible and practical, and we're going to exclude that from our community's legal system, just like we might exclude punishment from the system, even though you have the right to technically. So you can see prudential considerations factoring into those types of decisions, which is my solution is, which I wrote about, or I talked about it in Turkey at Hans Hoppe's thing a few years ago. I think the solution to the abortion issue is even if you regard late-term abortion as murder, when I think you could make an argument that late-term abortion is a type of homicide, the jurisdiction over that crime should be the mother or the family themselves, not the outside community. It's not until the baby is born that it's now the subject of that external legal community. So you can see considerations like that shaping the contours of these different legal systems. Like it starts with the mother and the family, and then the community's legal system, and then the outside world, which is only involving in war between groups or something like that, like onions or layers like that. Anyway, does that kind of make sense what I'm saying?
Yeah, it does. I mean, one of the ways I kind of presented the approach to the kind of grey areas with the Nations of Sanity project, because the way I obviously I haven't written that articulated any document like you have, but I kind of presented the kind of proposed peace agreement for establishing the non-aggression principles law as a three-part peace agreement. And part one is just the kind of basic agreement, which is the sort of thing that your universal principles of liberty could serve as a very useful, at least precursor for, if not with the supplements, maybe even something like that. But then part two is called Lines in the Sand, which is about drawing what I call the limits of tolerance over differing interpretations, kind of acknowledging that there are grey areas, but also saying, but there's also black and white, and we need to draw a line where we kind of segregate the fuzzy edges that we can't necessarily enforce with the black and white areas that we can enforce. And then part three is about ratifying rightful ownership. So my kind of approach to the kind of grey areas is because the thing is, with enforcing the non-aggression principles law, there's a lot of elements of our current legal system. Like, we don't want to throw the baby out with the bathwater, and there are certain elements of it that I think we would keep, like innocent until proven guilty, and also the kind of burden of proof as well, with regards to beyond a reasonable doubt. Because, as you say, we live in a messy, subjective world of human fallibility and all of those sort of things. Human interpretation. We can't completely escape that, but what we can do is we can,
I mean, look, there's a reason that these principles arose even on the positive statist law. There's a reason that there's a standard of proof and a burden of proof. There's a reason that it's higher for criminal than for torts and for civil debt, for contract breach actions. I mean, there's a reason these things emerge. And we don't have to just rubber stamp everything that the legal systems have done, but there's some wisdom in there. It's like Chesterton's fence. You don't tear a fence down if you're not sure why it was put up. Now, a lot of the times the fences were put up because of murky concepts and a not complete consistent application of principles of justice and statist involvement and some legislation here and there. But, you have to be a little humble when you do these things. And even in your black and white things, even there you could have hierarchies of how you treat them. Because, for example, let's suppose you have a community and you view action A as clearly on one side of black and white, which means it is clearly a rights violation or something like that. Even then, you might have differences in treatment of types of acts of aggression for outside communities. So there might be another community that's 100 miles away that is totally wrong in your view on that issue, but you still leave them alone because you don't extend the jurisdiction of your society to them unless they attack you, like in an act of war. So even then, even though you regard what they're doing as wrong, like let's say they murder homosexuals over there. Okay. We still might say it's still not within the jurisdiction of our legal system. We're going to leave them alone. Like, you see what I mean? I mean, it's you'd have to specify how this works out, but you see what I mean?
I understand, but I think I probably would push back a little on there, or potentially disagree, because I don't really go with the kind of geographical jurisdiction when it comes to kind of beyond black and white things. Now, don't get me wrong, there's a lot of practical reasons why you might not go invading another community because of blatant NAP violations, in ways in which you wouldn't be able to do so perhaps without treading on people's rights, or, there may be... Well,
are you visiting the entire world has adopted these universal principles?
No. That's my point. That's what I'm saying. It's like, there's many there's many practical reasons why. Let's say, for example, we had a Nations of Sanity revolution and established Napper's law in America and England and a few other countries. But then there's like Saudi Arabia where they're still executing drug dealers and whatever else. And my point is from a principle point of view, like I don't accept the geographical jurisdiction. So from a principle point of view, if we were able to do so, we would be entitled to go in there and
no, you're right. You're right. Yeah. My example is probably a bad one because you're right. Because I'm going back. I'm thinking. Yeah. So this is not like a police force that has a jurisdiction. It's just it's the legal rules that apply where there's enough community support to let them be put into practice. But yeah, you're right. We would say that by our principles and by our law, by the law we agree with is clearly black and white and justified, then that community is abhorrent. And yeah, so if you have a band of mercenaries or what's the right word, liberators or heroes or, what's the thing in the U.S. Constitution where they wanted to authorize privateers or something like that? If we would say, look, if you want to go over there and try to rescue the women or the homosexuals or whatever, you have every right to do that, of course. Yeah.
So I think, because funny enough, that was one of because although there's a lot of similarities between the Nations of Sanity project and the Live and Let Live project, that was one of the differences we have with regards to the approach to the grey areas, because the Live and Let Live project kind of did allow for like kind of community jurisdictions over grey areas. Whereas I kind of like rejected that because I felt like there's no community, there's no jurisdiction in that sense. So maybe an example would be we can enforce and the grey that we can't,
Yeah, so let's say some woman escapes from this Saudi Arabia thing, and then she hires a company to go kidnap the guy that tortured her or whatever, and brings him back to justice in our free society. Yeah, there's nothing wrong with subjecting him to whatever the justice would call for. I totally agree with that. Now, you could imagine other cases, I guess, where there's a reasonable difference, like, I don't know, the age of statutory rape or something like that, right? Where it's clearly considered rape if it's a 14-year-old girl here, but in this society, as long as she's 12, it's not, I don't know. And so it's rape here, but it's not rape there. I don't know how that kind of thing would be worked out.
Well, I mean, and I'd be interested to get your feedback on this. But I think something like that, because again, that's age of consent is a good example of a grey area, because we know where we stand with vulnerable children, we know where we stand with competent adults, but there's that grey area in between. But we can still kind of draw limits of tolerance over differing interpretations, which kind of leaves this grey area in between. And funny enough, this was one of the examples we kind of went through when I spoke to Mark Victor about our different approaches, because I was like, okay, well, in that situation, rather than the community enforcing a specific age of consent within the grey areas, as far as I was concerned, if you're going by self-ownership and staying loyal to the principle, then the person that has the authority over the grey areas in that domain will be the parents, because they're the rightful guardians of the child. And if it's a grey area, whether or not they are able to release them as an adult and kind of, wash their hands of responsibility, or whether it's a grey area where they've got to still, continue their parental responsibilities. My point is, because it's a little bit like other elements of parenting, like, we might disagree over things like spanking or even just how you the diet you feed your child, or all of these different elements. But what we say is unless someone's crossing over that black and white, now they're no longer a guardian, now they're stepping into abuser kind of territory and violating their duty of care to their children, until they step over that line, we don't really have the right to govern the grey areas to the parents.
Yeah, I agree. But so let me try. I'm trying to think of a good. It's probably hard to find a good example on the fly. But so let's say that it's fairly universally agreed that the age of consent for sex would have to be between 14 and 16. Let's just say. And some communities are 14, some are 15, some are 16. Okay. But now you have this other area where it's 13. And we all agree that that's totally beyond the pale. And so in our community, a guy that does that to a 13-year-old girl is going to be treated a certain way. Now, if we go kidnap that guy from his community where it's legal in his eyes at age 13, and we bring him here, we're still going to treat him as an aggressor. But you could see that they still might be treated differently, right? Because one guy did it in a system where it's known to be illegal, and the other guy did it where he's operating under the assumption that it's not illegal. So it might be like he might get a lighter punishment, or he might be treated like he might be given a little bit more lenience by the system. Just like
there's a difference in criminal intent, isn't there? Like mens rea.
Correct. Yeah, it would go to the intent. It's just like I've argued, like if you steal someone's horse for one reason, there's different examples, but if you break into someone's cabin because you're just a squatter, that's just pure trespass. But if you break in there because it's the middle of the winter and there's an empty cabin and you have to feed your baby, they're both acts of trespass, but they might be treated differently by the owner themselves, right? And by the community. They might be regarded differently because the purpose, that's another thing in my writing. I distinguish between intentionality and purpose. They are different things. They're quite often conflated by laymen and by lawyers. For an action to be something that you could be liable for, it has to be an action. An action by Mises is the use of a resource to achieve an end. That means it's purposive. It means you're trying to achieve a given purpose. That's your end. But it's intentional in that it wasn't involuntary. Like if I have a seizure and I slap you with my hand, I'm not even liable at all because I didn't do it. It was not an action. It was an involuntary thing. So when we look at an action and we want to determine culpability or liability for doing something, number one, it has to be intentional to be an action. So that's the intent part of it, which people talk about mens rea, right, in the law. But the purpose is why you did it. If you did it to feed your baby, that's different than doing it for some other shallower reason, right? And I think that the intentionality is what has to be there for there to be liability. But then the criminal system would look at, if it's even a criminal system, but whatever we're going to call this system, whether it's ostracism or restitution or even punishment, whatever it is, you take into account the purpose as well. And that's where the leniency part might count in. So if this guy commits rape on a girl, I don't even want to call it statutory rape, because that assumes legislation, but it's the same concept. It's like it's too low. If a guy commits statutory rape on a 12-year-old girl in his homeland, but it's not illegal there, then it's still an intentional action. So we still regard it as rape. But the punishment or the response might be moderated because his purpose wasn't as sort of obviously evil. You know what I mean? Something like that.
Yeah, I mean, it's a little bit like how obviously ignorance of the law doesn't excuse breaking it, but there is a certain, there's a difference with intentionality with regards to the mens rea and also going back to the example of, like, say, the mother who maybe breaks into your home because her baby's starving or something and takes something. She might argue that, well, I was invoking implicit consent because I thought that in this situation you would give me consent. You could turn around and say, well, no, I don't give you consent, and now you owe me for the apples you took. But that's not the same as if she knew that you didn't consent and it wasn't in any kind of emergency situation and she's just a thief. So there is, but in both situations she's guilty of theft. But one of the situations, there's much more intentionality on her part, criminal intent, mens rea, however you want to kind of frame it. So I think. Yeah,
by the way, the comment you raised, not to nitpick because it's an interesting comment. You said ignorance of the law is no excuse. That maxim arose because, and actually I disagree with that maxim, because that maxim only makes sense in a world where there's statutory law. In other words, where there's malum prohibitum law as opposed to malum in se law. In a just world, in a libertarian world, basically all law, or at least all the principles, are these common sense principles in my universal principles of liberty. And you could say that's what we say in the natural law. They're engraved on your heart. In other words, if the only law was you can't commit robbery, rape, or theft or murder, then someone could not have a defense saying, well, I didn't know that. You would say you did know that because everyone knows that. But if you have a system where no one knows what the law is because it's just there's literally millions of statutes, like literally in England and in America and in Europe, there is not a single person, there's no organization who knows how many laws there are. No one knows because they're just made up every day by regulatory agencies and statute and by legislatures. And they're not they're not categorized by number or something. So no one knows how many laws there are. So when you have a system of arbitrary law, which is not just law, and which is malum prohibitum law, I think ignorance of the law should be an excuse, to be honest. I think it should be, but the government doesn't want it to be an excuse because that would let you get out of too many arbitrary, unjust laws. Just as a side point there. So I think really, in a way, ignorance of law is an excuse because there is no ignorance of the basic law of human nature. We all know these things.
I agree with that. I suppose I was really talking in the terms of obviously disregarding arbitrary laws and only thinking about objective law, because obviously, and a point's been often made to me, particularly from people that kind of criticize my, idea of NAP law, when they sort of say, well, making it law doesn't validate the NAP. The NAP is, valid as a principle, regardless of whether you establish it as law. And I say, yes, that's true. That is very, just like before we abolished slavery, it was illegitimate. People didn't have a right to own other people, even before we abolished slavery. But until we made that formalized recognition that slavery is a crime, it was practiced as a, as a legitimate part of commerce, So I think it's important that people kind of understand that distinction between, yes, we're not saying that the NAP is only valid because we're making it law.
Yeah, but what I'm saying is,
law to be made aware of, you don't have the right to rape somebody. So if someone could say, well, I didn't know there was a law against rape, it doesn't matter. You still.
I know, but I think my point actually supports you, because in the case of slavery and rape, ignorance of the law is not an excuse because you're not ignorant of the law. Everyone knows that it is wrong to commit murder and rape. Like, even if it's legal, you know that it's wrong.
Yeah.
I mean, people knew that slavery was wrong.
Yeah, no, I agree. I suppose the point I'm making is I agree with that. But the point I'm making is the reason why I was saying ignorance of the law is no excuse, because I was speaking in the terms of NAP law, and because my point is ignorance of the law shouldn't be an excuse because there shouldn't be arbitrary laws imposed on people.
Exactly.
All of these additional arbitrary things should only be part of voluntary covenants and agreements and collectives that people consent to, which, like you mentioned, like the whole covenant community idea. That's perfectly acceptable and probably a desirable course of action. Like if we were to establish the NAP as terms of peace, defining kind of crime in that kind of hard way, that still provides a foundation where people can still get into collectives, whether it's a homeowners association or whether it's something like a covenant community. The fact of the matter is there's a lot of incentive for people to get that extra clarity in the grey areas where everyone knows where they stand. But my point is even absent those agreements, even absent those specific contracts, we still need to have our kind of black and white kind of foundation where we say, okay, well, everyone has a right and ownership only themselves. And that at least gives us a kind of principle-based definition of crime and law, even if we still have to kind of pass our way through, certain specifics. Does that make sense?
Agree. It does. And I guess I'm actually agreeing with you because you're right. Ignorance of the law is no excuse. But the reason is because we're not ignorant of the law. Because by law, we mean the kind of self-evident, obvious principles of human interaction, right? That are known by everyone. I mean, a thief knows he's a thief. He's not ignorant of the fact that he's a thief. He knows he's stealing. A rapist knows he's raping someone because he's saying no. I mean, so people are not ignorant of the law. And so anyway, it's not an excuse because they're not ignorant.
Yeah. I mean, even animals understand aggression on a basic level. So no human can rationally plead ignorance on that front. So I mean, one of the things about and this is another reason why I was so keen to have this conversation, not just to kind of discuss the universal principles of liberty and how that kind of relates to like my own project and my own work, but also like there's certain kind of approaches to this that I think kind of come from the principle that I think we can clarify. Like, again, it's drawing that distinction between where there's a lot of disagreement because people are misunderstanding things and getting things wrong, and where there's kind of genuine grey areas. And I think we can kind of segregate that and kind of bring a lot of clarity. Like for example, one of the things that's often said to me about this whole black and white and separate, the limits of tolerance and separating it from the grey areas. And one of the things that, again, I point to where we don't want to throw the baby out of the bathwater with our current legal system.
Matt, hold a second. Matt, give me 10 seconds to I need to grab a bottle of water.
Yeah.
Give me just a second.
Yeah, no problem.
Sorry. Oh, I'm back. Go ahead. I'm just it's 90 degrees out here in Houston.
Yeah, no, it's pretty hot here. I've got my trusty bottle. Yeah, no, I'm just going like with regards to kind of the approach that I've taken with the Nations of Sanity. One of the things I've said with regards to drawing the limits of tolerance over kind of differing interpretations over what is aggression and what isn't. And I've kind of said, well, look, we should take the same approach that we do. You know, when I said, oh, we don't want to throw the baby out the bathwater with certain legal approaches. And one of the things is the innocent until proven guilty. And the other thing is the burden of proof. If we're going to criminally convict someone, we need to know beyond a reasonable doubt. And like, as you mentioned or alluded to, there are important reasons for that. And going with our NAP framework, and the self-ownership framework, I would say that the important reason for that beyond reasonable doubt standard is that if you convict somebody with far less certainty, then you're guilty of criminal recklessness because you're applying force on a potentially innocent person. And I think not only can we apply this to whether somebody is guilty or not of committing, say murder, rape, whatever the crime is, but also when we're even talking about what is and isn't a crime. When we're talking about that grey area versus the black and white over whether something is a non-aggression principle violation, I just say we would take the same approach. If it's beyond a reasonable doubt that this is a non-aggression principle violation, doesn't have to be, I mean, often liken it to a maths thing. Sometimes it's very simple. Rape is like 2 + 2 = 4. You don't need to be a genius to work it out. Whereas maybe IP law is a little bit more like 42 + 110. It's still pretty simple, but it needs a little bit more thought. And maybe some people get it wrong, So my kind of approach with it is, and that's why I kind of segregated the peace agreement into these 3 parts of saying we need the basic agreement, we need our lines in the sand and our approach, to differing interpretations. And then part 3, as I say, is about rightful ownership, which is just ratifying property rights based on this principle. But I really think that we need to kind of take the same approach as we would with regards to whether we're ascertaining someone's guilt of a crime as we would whether we're even asserting whether the act is even a crime. Does that make sense?
It does. And by the way, not to be nitpicky, but this is something you might be interested in. In the law, there's a difference between the burden of proof and the standard of proof. Okay, the burden of proof is what you have is the fact that one party has to satisfy a burden of proof to make their case. In other words, things are going to stay the same unless you prove your case. So if someone is in possession of a house and you claim that you own it, you have the burden of proving that it's yours if you want to get the house back. Or if you accuse someone of a crime to punish them, you have the burden of proving that they did it. But the standard of proof is how you have to prove it. So the standard is beyond a reasonable doubt, or clear and convincing evidence, or preponderance of the evidence. So those are actually different concepts. So for example, if there's a property dispute about who owns, I don't know, a house or a horse, then the standard of proof is preponderance, which means so the person making the claim to change things has to satisfy his burden, but he might prove it by what we call 51%, just more likely than not. Because the legal system has to have an answer to the question, who owns this house? And you should give it to the one that has the better claim to it. So it should be preponderance of the evidence. Because even if you make a mistake, you still have to give it to someone, so you might as well give it to the one that there's better evidence for. But if you're trying to upset the order and commit an actual act of force against someone's body, which is an act of aggression unless they actually committed the crime, that's why you have to have a higher standard of proof. And that's why I think that a restitution system would be more feasible, because you don't have to prove beyond a reasonable doubt then. If you want to punish someone, you have to prove beyond a reasonable doubt. And that's going to be harder to do, more expensive. And if you're wrong, like you said, you're committing an act of aggression yourself, and now you're liable. And also insurance and reality is going to play a role in this. Unless you have an insurance carrier backing you up, that keeps you from being regarded as a risk to everyone, an uninsurable outlaw or wild card, you're only going to get insurance from a carrier if you get enough coverage to cover you for acts of aggression, for whatever you do. And they're going to charge a lot more if you want to go punish someone, rather physically beat them and maybe execute them, as opposed to just punishing them for getting money damages for them. So I just think the costs of a punishment system would be so prohibitive that it just wouldn't be likely to emerge in an institutional way.
Yeah, I mean, just going back to the property example, would it not make a difference? Like, for example, if there was a property dispute, let's say, for example, a house was left in a will, but there was some ambiguity over who it was left to. So neither person had the house, and you're just kind of assigning, who should get it. For me, then the preponderance to 51% seems perfectly valid. But if you say, I come along and say, I'm the rightful owner of your house that you're currently living in, for me, that's when it steps into the beyond reasonable doubt, because for me to take your house from you would be an act of aggression that I would be risking. Whereas, like with the example of the house that's left in the will, me just assigning it incorrectly, I'm assigning it to the one that has the preponderance to 51% more likely. I'm not aggressed against anybody. Whereas, I
hear you, and let me tell you why I think I disagree. Although, again, this is a little bit academic because we're trying to guess what all these nuances, how they would develop in a practical legal system. But all we have to go by is how systems have done it before. And that's why knowledge of the law is somewhat helpful. So these situations are actually covered in the law. So the will case, so when there's a movable item, a personal item, or there's an unowned or unpossessed house, a thing like a house that's left in a will, yeah, you're right. There's no reason that wouldn't be preponderance, because the legal system has to recognize. So the legal system's role is to recognize property rights by our basic principles and to apply them when there's a dispute. Okay. And so the burden should be on the person trying to upset the existing situation. And the standard should be preponderance, I think, something like that. If someone's in a house and then the law they have these interesting nuances, like, so if you're in my house and I say, I realize that when my grandpa died, he left it to me, not to my brother, but he's been living in it because, we didn't check or whatever. So now I want him to leave the house. But I'm not going in and physically kicking him out. I'm taking him to court, and I'm getting a court to make a decree about who owns it. And if the court says, okay, you're actually the owner, now that house is recognized as mine. Now he is the trespasser. And if he doesn't leave, he's committing trespassing against my property, right? So then I just have whatever rights I would normally have to oust a possessor. So I don't think that I'm not threatening to commit aggression. I'm asking the legal system to recognize who owns the house. And once they recognize that by a preponderance of the evidence standard, then we can use whatever the legal system would do to kick any homesteader or any squatter out of my house. But there's another case where, for example, I go on vacation and I come back and there's some squatter in my house. So the law, rightfully, in my view, is different the situation where the first situation and the second one. The second one is I give a lease to someone for 10 years, or they say it's for 10 years, but I say it's for one. We have a dispute and they're in there illegally, but then they won't leave. They're not really possessing it illegally. There's just a dispute about what the term is. And so that's when you go to court. But if someone just comes into my house when I'm going on vacation, they're a squatter, they're not even rightfully possessing it. So the law actually distinguishes between ownership and the right to possess, and then possession, which is a factual matter. So it's sort of in between. And you can see how these things would emerge, right? So I think that for any property dispute, probably the burden should be on the person asking for you to change. But that might change in the case of someone who came into my house when you still have the burden of proof of proving that he's a trespasser. But once you prove he's a trespasser, then he can be ejected. I don't have to go prove title back to Adam. Anyway, I can see these nuances working out, but I still do cling to this idea that in any rational legal system, it would be almost all property and restitution based, and not criminal punishment at all. So there would all be the preponderance of evidence would be the standard for everything. It would never be beyond a reasonable doubt, because you're never seeking permission to violate someone's body.
But would it not potentially come to that though? If like if you're talking about evicting people and things
Yes.
like that, that's why. And I may well be wrong on this, but just to kind of clarify why I'm thinking the way I am about this. The reason why I don't have a problem with the will example is because I don't see any aggression there with assigning it one way or the other with a preponderance of evidence to 51%. But when it comes to me, wanting to kick you out of your house and you're disputing that, if I don't have a beyond reasonable, doubt level of certainty, and I escalate that to some kind of violence against you where I'm, physically removing you or whatever.
Yeah, but you're not. You're going to the legal system, you're getting a judgment, and then you're using the legal system to enforce that judgment. You're just to enforce your property rights.
So would it be fair to say, correct me if I'm not thinking about this correctly, but would it be fair to say that the preponderance of evidence is being applied to the dispute over who the property owner is?
Yes.
Once you've got that, you've then got the beyond reasonable doubt standard that you're trespassing because it's not your property. Would that be a fair way?
Yeah, I mean, well, let me ask you this. Suppose you're on your farm, minding your own business, and some guy walks up and he pulls a knife and he's trying to stab you, and you use lethal force to kill him. I mean, did you prove your case beyond a reasonable doubt? There's no forum.
Somebody else would need to prove beyond a reasonable doubt that I see what you're saying. Yeah.
No, but my point is the standard of beyond a reasonable doubt is not applicable to your individual actions, like in the case of self-defense. It's applicable to the way the legal system decides who is the owner of a resource. So the legal system should consult its basic principles and its developed body of law, which tells it who owns this resource in the case of a dispute. And that's going to rely partly on the facts that we know, the evidence that we hear, but sometimes there's conflicting evidence. So you have to go with who has in the end, on balance, the best claim to it. And whoever has the best claim ought to be recognized as the owner. And I can't see how that's going to be. So if you make it a beyond a reasonable doubt standard, then if someone just takes my watch from me and they get away with it, now the only way I get that watch back is to prove beyond a reasonable doubt that it was my watch. And I just see problems with that because it makes it too easy to get away with crime. Like it basically makes the law almost nothing because it makes possession 99 hundredths of the law and the whole point of a legal system is to be a layer on top of possession to say who should possess. But if it's just like, everyone who possesses should be the owner too, unless you can prove beyond a reasonable doubt that they're not, then the law does almost nothing.
Well, I mean, I think a desire for those sort of standards can still be, put into like covenants and stuff like that. But I suppose the reason why I'm averse to the preponderance of evidence and prefer the beyond reasonable doubt approach when it comes to this is because the way I look at it is, well, as I said before, if we lack that beyond reasonable doubt certainty and we use aggression against somebody, then that seems to me that we are guilty ourselves of criminal recklessness. Do you know what I mean? It's like for example, if this is the big reason why a lot of people are against the death penalty, because they say, oh, well, what about and I understand the death penalties are much more final than some kind of lesser kind of criminal punishment where some kind of restitution or correction can be made. But the point still remains the same. If we lack that beyond reasonable doubt certainty that someone is guilty of a crime, therefore the force we use against them is justified, then are we not ourselves guilty of criminal recklessness by applying force to people when there's a genuine chance that they're innocent?
I think it's tricky to sort it out. But when we say that trespass is a crime. Okay, any kind of trespass, including rape and murder. That again is a dependent concept that rests upon principles of property ownership, and those property ownership principles are not a court. They're not based upon beyond a reasonable doubt. Like if I say that committing murder or committing an act of theft against me is a crime if you can prove it beyond a reasonable doubt. But the reason it's a crime is because it's using my resource without my permission. But how do we know it's my resource? It's my resource because the legal system recognizes property rights in things that are contestable by the basic principles of self-ownership and homesteading and contract. But it doesn't say that you own your body if you can prove beyond a reasonable doubt. It doesn't say that you own this unowned field if you're the first one to use it because of a reasonable doubt standard. It's because the principle says that the first one to use an unowned field is the owner. Like that is just the property rights principle. It's not anything to do with the burden of proof at all, or even a standard of proof. So enforcing any kind of law that prohibits trespass or aggression presupposes a legal determination of the owners of things. And that legal determination is not based upon this beyond a reasonable doubt standard. It can't be because, again, it would mean that the legal system is nothing more than a slight window dressing on top of bare possession and might makes right.
Why though? I'm not following you on that one. Like, why is... Well, I don't see why if law is being applied with this beyond reasonable doubt standard across the board, I don't see how that's making it impotent. Like, we apply that to criminal cases already, even in our current legal system, and we still are able to convict murderers and rapists and thieves, based on that. And that seems to me very much a kind of that's part of the baby we don't want to throw out with the bathwater with regards to kind of our approach to punishing criminals, because again, I don't want to kind of say the same thing again, but it's just to kind of kind of really specify my point, or the reason why I have this position I do is I can't get away from the fact that if I lack that like the same reason why I need a beyond reasonable doubt certainty to convict you of murder, because the punishment that I'm going to administer would be itself a crime if you were innocent of this. And if I lack the reasonable certainty or beyond reasonable doubt certainty that you are guilty, then I am myself guilty of criminal recklessness. I can't get away from that across the board of natural violations,
Okay, so let's say that there's, I don't know, let's say I built a house in an area and no one's around. It's like I've homesteaded in an area, I've homesteaded a house, but I'm alone. And then eventually people move in nearby and there's a little neighborhood, right? There's a little community. And as far as they know, I'm the possessor and I'm the owner of the house, as far as they know, right? I leave town, I come back, there's a squatter in my house. Now he's in the house. And I want people to kick him out. Now, if your standard was applied, I couldn't eject him, or I couldn't get a judgment saying I'm the owner unless I can prove beyond a reasonable doubt that I'm the owner. Which means that he got away with it. Like I'm screwed. I've got to wait till he leaves town and then take it back. Do you see what I'm saying? So in other words, I can't prove beyond a reasonable doubt. I don't need to be able to prove beyond a reasonable doubt that I'm the owner of the house. I just need to have a better claim than anyone else to show that I'm the owner of the house. To use aggression against someone, and in fact, I don't even think you need beyond a reasonable doubt to use aggression against someone. It's just that beyond a reasonable doubt just means that the legal system can't treat someone as an aggressor in an institutional way unless it's proved that he certainly did it. Like, that's the whole point. So you might have someone get away. We say they might get away with the crime, but he actually did the crime. But he did the crime because we recognize that the body that he touched was self-owned by the person that was the victim. We just can't prove it beyond a reasonable doubt. We can't prove for sure he's the one who did it, but we don't have to prove beyond a reasonable doubt that the person murdered owned his body. You see what I'm saying? The standard of proof only applies to the institutional punishment of a criminal. And I think that when you make a property decision about a dispute between a resource between two people, I mean, if you have a contract, like how would you what if the two children who claim to inherit the house from their grandfather, they both claim they own it, but neither one can prove beyond a reasonable doubt that they own it. Like one has a 75% case and the other has a 25% case. So does that mean no one can own the house now?
Well, no, but like the reason why I don't mind the preponderance of evidence in that circumstance is because that's not proceeding an aggression against anybody, because neither of them have the house, and then it's just whoever has the higher claim of it is the one who's going to be sort of recognised as the owner.
Yeah. So if one happens to be living in the house, then he's effectively got it. So again, possession in your view is 99%, 99/100ths of the law.
I mean, I suppose I'm not looking at it that way, but I can understand why you're saying that. I mean, I mean, from my point of view, it just comes back to that. If we need that level of certainty to apply the force, you know.
Yeah, I know, because what you're thinking. I know what you're thinking is, if the court decides based upon anything other than certainty that the guy challenging the current possession is the owner, that will lead to the use of force to evict the guy if he doesn't comply, right? So you're saying the next step in the process, which is true that in a sense, like we say, voting ballots is just another form of bullets, right? Because all law is ultimately enforced by the point of the gun, ultimately, right? And I agree with that, but I'm very confident that I'm right, but I need to think of a better way to articulate it. So I'm thinking partly like a lawyer so used to the way this works, because I can't, not only can I not see another way around it, but I don't see a problem with it. I mean, I think that if someone in a peaceful, civilized system, if someone has your resource or you think they have it and you want to be civilized, what are you supposed to do other than taking the law into your own hands? You're supposed to go to court and make a claim that it's really mine, the guy should get out. And I just don't see why you would have to prove that beyond a reasonable doubt. Because if let's say you prove it with just a preponderance of the evidence, now it's been judged by the court and the legal system that you're the owner. That doesn't necessarily have to lead to aggression. Now you have a guy he's the one committing aggression. And if he doesn't leave, he's committing aggression.
Yeah, I mean, well, that's why I was asking if the way you're if I'm thinking about it correctly, the way you're laying it out is that even though you're using a preponderance of evidence to ascertain the rightful owner, once you've done that, you then have the beyond reasonable doubt certainty that that person is trespassing because they're definitely in the house and refusing to leave.
And I would agree with that. But I think that, again, usually that standard is for court proceedings. It's not for so the enforcement action would be, look, I've gone to court. I've got a judgment that it's my property. The guy won't leave. I'm going to get the sheriff and go kick him out with force. And now we know we have a right to do it. And if he escalates, then we can escalate, right? So that's when it would get. But at that point, we're going on the foundation of the recognized communal legal judgment of who owns what. And given that understanding, this guy is now using my house without my permission. He's committing an act of trespass, and I can use reasonable, proportionate force to make him leave. And I can't just go in there and shoot him, but I can escalate it if he escalates. Anyway, we're getting into details, but it is interesting stuff. But
I mean, it's probably, perhaps we should put a pin in it, because just as you said about, like, you know, you maybe need to think about it and a better way to articulate it, I kind of need to as well. You know what I mean? Because this is not an area that I necessarily expected to have a disagreement over. And as I say, like, from my point of view, I try to keep it simple in my kind of approach with it. And I suppose it is really just because the force that I'm going to want a judge to use to evict somebody, I don't see the fundamental difference than the force I would want to say that person's a thief or a rapist or a murderer and we need to go and lock him up. Like, either way, I'm asking someone to use force, or I'm going to want to use the force myself, or whatever the situation is. And I'm just saying that it seems to me intuitive that we need that standard of certainty to administer force against people. Otherwise, we're potentially guilty of criminal reckless aggression against other people if we lack that certainty. So, I mean, perhaps put a pin in it for now, and perhaps we can both have a sort of think about that and maybe revisit that element of it. Because I won't lie, I'm not 100% convinced to abandon my beyond reasonable doubt approach to NAP violations. Like I say, as long as they are black and white. And I still think this still gives way, because we can still go to covenants and collectives, which are all perfectly permissible upon the foundation of NAP law, where we can have these agreements to adhere to preponderances of evidence and, and different grey area standards that we wouldn't otherwise be able to enforce absent those agreements and covenants and what have you. So, we still have options of ways we can deal with it. And if it is unappealing for people to, in fact, I think that's very much how it would work when I think about how, we would work. As much as I want this NAP law as this kind of universal black and white law, I do think that communities and collectives would still formulate their own kind of more minutiae rules, but that will be subject to consent. That's the kind of fundamental. Like the reason why I separate the NAP law is because I don't need consent from a rapist to enforce laws against rape, but I do need consent from, say, a homeowner to enforce a preponderance of evidence standard to a victim or something like that. That's kind of like my thinking on it.
I think as a practical matter, I think any working society you can imagine, even if they went with your standard, which I don't think they would, but if they did, they would override it with an agreement. They would say it's just not, we don't have property rights.
But that's fine though, because that's not overriding it. That's just playing within the paradigm I've already set up, because that's why I don't have, because I do try to emphasize this, I want NAP law, but covenant communities and voluntary collectives and all of these things, people can still enter to agree to other rules that have nothing to do with the NAP. Some of them can be, I think Dennis Pratt from the New Hampshire libertarian thing, he made the point to me about when I said about the NAP's the only enforceable law, and he made the point. He said, well, no, you can have all these other rules that people agree to as covenant communities. And I'm like, yeah, but that's not law that we're enforcing on everybody. That's rules that people are agreeing to, which is just because the whole point of it is about self-ownership. The reason why I can enforce, NAP law against you is because of self-ownership. You don't have the right to rape, murder, and assault, so I can use the force to stop you doing those things. But all these other kind of covenants that we would then enter into, that's still just an exercise of self-ownership. So for me, it still just follows. And for the reasons you've laid out, I would argue that a lot of these covenants would be incentivized because they want these standards within the grey. But I just think that requirement for consent, we've still got our foundation of our black and white NAP, and then we've got the incentive to then have these more refined minutiae rules, but those things will require consent, which I think the incentives would still be strong for people to consent to that, because you're going to want to own a property where you've got these clear rules on what protects your property and what doesn't.
Well, and I think that excuse me.
Bless you.
I think that this is a little bit afield, but this is where the debate about voluntary slavery and Walter Block's views comes into play a little bit, because I do think that there are limits to. So some people say that you can agree to whatever you want ahead of time. I don't know if I totally agree with that, because you can't give up certain rights in a sense. And one example is Walter Block came up with this. Well, it's called Murder Park. Look, if you want to have people boxing in a ring or fighting a duel with each other, I think that's fine. But if I agree to box Muhammad Ali in the ring and he kills me, he didn't commit murder because I consented. But if I agree to fight and I decide to back out, or I'm in the middle of it and I want to jump out the ring, and they say, no, you agreed to stay in here. You can't leave. I agree. I disagree with that. I think you can leave. So if you have a community where people have agreed to these things, you can't agree that I hereby give up my right to leave, for example. I think you can leave no matter what, even if you promise not to. So And you can't like have a store where the owner says, "Oh, there's a sign up saying, you know, if you break a pot, you got to pay for it." Okay, that's reasonable. But if he has a sign saying, "You're on my property. If I judge in my sole judgment that you do something I don't like, I can kill you," and he does it, I think is murder, right? Or it could be, depending on the context. So I don't think that I think there's a limit to these background rules that these covenant communities can adopt. But ultimately, I think that they're basically they're setting default rules and standards of proof and presumptions, but they're not. You cannot alienate ultimately your core fundamental rights.
Well, yeah, I mean, I don't know if you remember, but I actually moderated a debate between you and Walter on voluntary slavery. In fact, I might put a link to that in the description because that's definitely worth a watch. And I do, generally speaking, I might quibble about the murder example, but generally speaking, I agree with you on the voluntary slavery side of it. And I'd be interested to know whether I agree with you for the same reasons that you make it. But basically, the reason why I view, like, for example, you can't be held to a voluntary slavery contract, or you can't rape a prostitute who signed a contract, or, you know, these things, you know, they have the right to back out because basically what they've offered to give you in the contract is an inalienable right that they can't really give you, you know. So that's kind of invalidated the contract. Or like they can give consent to a contract, but they can withdraw consent, and that doesn't give you the right to murder them or rape them in the example of the prostitute, stuff like that. But for example, if we had a property transfer, and that's why I think the property thing is different on this, is let's say, for example, you had a deal with a prostitute where you know, like you have sex. If she backs out, you get her car. Then for me, it's perfectly acceptable to say, okay, now you own her car.
Agree. Totally agree.
I mean? Because that's a different thing, because she can give you her property, but
yes,
she can't
100%.
give you herself in a way that she can no longer withdraw her consent and stuff like that.
Totally agree. I totally agree.
Yeah. So, but for me, because that difference is the inalienable right versus the property side of it, that's why I still think the covenant thing is fine, because we can still use covenant for all this minutiae with regards to property.
Yes,
but
agree. As long as long as it affects property,
we have
basically.
Slavery covenants and things like that, or at least not one that could be enforced, or rape covenants or anything like that, because people's right to consent. I mean, it's a little bit like, I mean, one example I often use with that is, like, you know, we have quote unquote sex slaves today, but they're not really slaves. They're people that are indulging in fantasy horseplay, you know, and all that sort of stuff. They still have the right. And if one of these sex slaves, you know, said his safe word, or, you know, said, I don't want to do this anymore, whatever, and he was forced to carry on, then they would be guilty of rape and assault and all the rest of it. You know what I mean? Because he's not really a slave in what we're really talking about when we say slave. Just like I mean, you know, because at the end of the day, and one of the things I felt like became very apparent in your debate with Walter was, when it comes down to a voluntary slavery contract, it's really not much different to an employment contract. You're just promising to fulfill this particular role, and you have the right to consent to that, but you also have the right to withdraw that, and your inalienable rights is always intact throughout.
Totally agree.
So,
by the way, as an administrative matter, I've got to go in about 15 minutes. So if you wanted to get to anything else, like maybe how to integrate the principles with your anyway, or we can do part 2 later if you want. But in about 15 minutes, I've got to go.
Yeah. To be honest, I didn't realize the time was creeping on that much. But yeah, well, to be honest with you, I mean, perhaps we'll go for another 5-10 minutes if we can. But I think there's a lot more meat on this bone, so I'd be very much up for a part 2 another time if you would be up for that. Yeah, that would be great.
I would.
And perhaps a little way to finish this conversation off and just kind of segue and prepare for a part 2. Oh yeah, just to kind of, because this is coming back to the reason why I want to have this conversation with you, because obviously I present my little Nations of Sanity project saying, you know, we need to make the NAP the law, and we need to do it through a peace agreement. And one of the reasons why I really emphasized the peace agreement, and I think you made a point on this when you were talking about your aversion to this status, constitution, like things like that, because it's still there's a contradiction in the principle. And one of my big kind of selling points with the idea that I present is to say, well, look, this is the only way we can establish the Napper's law without contradicting the principle, rather than making it the dictates of a ruling authority, which would obviously contradict the principle. We make it the terms of a peace agreement, like a bottom-up peace agreement. And one of the things, I was talking to Adam Heyman, who we both know, and he was doing a good job of really kind of pressing me for kind of more clarification on what it is I'm really kind of, proposing. And one of the things I tried to do in response to him was kind of point to precedents that already exist. I very much liken what I'm trying to stir up and what the libertarian movement kind of is, or at least should be in my mind, which is very much akin to a modern day abolition movement. Like, we had the slavery abolition. Yeah. And I just feel like, well, libertarianism is really about just doing that, but doing it right, because we abolished this very narrowly defined form of slavery, but we allowed statism, which is just another form of slavery, to continue. And also the other problem is we abolished it primarily under the dictates of ruling authorities. I know it was later ratified into international law through peace treaties, but again, that's the other issue with the contradiction to the principle, is this top-down authority. And then also I pointed to things like international law, because a lot of people struggle to conceptualize law and separate it from ruling authorities. They're like, well, you can't have law without governments. And I'm like, well, you can, because even today, as imperfect as it is, I can point to international law as an example of a bottom-up peace agreement that's established a law. Now, obviously, that's between nation states, which are illegitimate, and what I'm proposing would be between individuals.
And there was also the law merchant, which was a functioning body of law for centuries, which didn't have any governing authority. And there's another one you made me think of. And there's a great pair of articles by a guy named Alfred Couzon. Have you ever read this article? It's called "Do We Ever Really Get Out of Anarchy?" It's a classic article. It was in the Journal of Libertarian Studies, I think in 1977. He wrote a follow-up years later. But he's not even a libertarian or an anarchist. But his point is that it's sort of like a sophisticated version of the libertarian critique of the state. Like, we argue that you cannot have a binding constitution that limits the state, because the state itself is the one that assumes the authority to interpret it, right? So it just doesn't make any sense. So if you really are a Hobbesian and you think that law doesn't make sense without a sovereign, but you want a limited sovereign, it's just not you can't have both, really. But his point is that the state is it's just a concept we use to describe a group of people doing things together. We organize our concepts around this concept of state, like corporation or whatever. But the people inside the state are just human actors, and they're all obeying certain, like if the president orders someone to drop a bomb, he's not forcing them to do it by pointing a gun at them. There's actual a hierarchy of authority. So there's, in a sense, in the state itself, there is anarchy in the state, within the state. So that's why he said, do we ever really get out of anarchy? And we don't. In other words, there's always anarchy. It's just, what form should it be? So in other words, there's always there's 8 billion people on the earth, and some of them are in this dotted line we call the state or the government, right? Employees of that agency. And they all are resting upon the sort of implicit legitimacy or authority of it. But that rests upon this hierarchy of the commands given by their boss and the courts supervising it and ordering things to happen. It's very complicated, but it's basically every one of their actions rests upon voluntary consent among voluntary responses among each other. Because, like I said, I mean, I've argued if you don't believe in responsibility for joint crimes, which I agree with, I think the common law is right about that. Like, if I'm a mafia guy and I order my underlings to go commit a crime, rob a bank or kill someone, I think it's proper to hold the hitman guilty, but also me, because I play a causal. That's just the reality of this. That's the causal reality of the situation. even though, but some libertarians say, no, it's only the hitman, because the other guy just spoke. He had free speech. He said he wanted you to do it. He didn't force you to do it. So by that logic, Adolf Hitler was in principle guiltless, because he just gave people suggestions. He wasn't forcing all the Nazis to kill Jews with a gun. So the example I gave is, if you have like a Jewish woman kidnapped and her husband's in the concentration camp, and she's Hitler's maid, and he's alone in his office one night, and she has a chance to grab the letter opener and kill him. According to these guys, she's committing murder, because he's not an aggressor. It's like ridiculous. Of course he committed murder, right? So context matters in all these.
Sorry, I was going to say, it was a little bit like the difference between you picking up a gun and shooting someone, committing murder, or you paying a hitman to pick up a gun and shooting somebody. In the first example, in both examples, you're guilty of murder. But in the first example, you're the only person guilty of murder, because the gun isn't an agent of itself. Whereas in the second example, you and the hitman are guilty of murder, because, if the gun was a human being that you were pulling the trigger of, then that person would also be guilty of murder as well. But because a gun isn't a moral agent, obviously only you're guilty. But you paying a hitman to do it for you doesn't make you less guilty than it would if you pulled the trigger yourself. So I 100% agree with that. And just getting back, so that's kind of obviously, and as we're all doing as libertarians, we're working our way through this principle, just trying to refine it and get better clarity and see how it can be applied in the real world. And when I'm kind of looking at the whole Nations of Sanity idea of NAP law, I've been looking at these different precedents. I pointed to international law and like merchant law, and there are other examples of law that's established through terms of peace rather than through a top-down dictate. And I looked at the abolition movement as an example of what we're trying to do. But I also pointed to your universal principles of liberty as an example of the non-aggression principle formalized into the form of an agreement. Now, I do always, whenever I've mentioned this, I have always added the caveat that, one, you haven't presented this as a purpose for establishing law, and two, in its current form, it lacks a lot of the clarity that it would need to be established as the foundation for law, which was why I was very interested when you mentioned about the addendum and the supplementary material that you're working on, because then I feel like that document would then get a lot closer to being something that could be a foundation for law. But you're saying it would still probably fall short of that for law.
Well, I could see, like, and we could talk about this later, but I could see, let's see, you come up with some kind of skeletal or draft concept for your whatever form your agreement's going to be. And that agreement says this agreement is based upon and has reference to universal principles of liberty, maybe the supplemental principles, and also, say, the Louisiana Civil Code as a starting point, to the extent that it's compatible with those things. And
like
then
exercise get rid of the statist parts and just keep the rest, basically.
You don't have to do it. You can say it in your agreement would say, we apply these fundamental principles, they're primary, and the supplemental principles, and also, or you could or the Uniform Commercial Code in the United States, or the restatements of the law in the United States, or if there's something else equivalent in some other country, or you could even say the civil codes of France, Germany and Belgium, to the extent that they're compatible with the basic principles. I mean, you could set out a starting point that you would direct your arbitrators to consult in the first cases, and then they would gradually develop a body of law. But it wouldn't be too skeletal. It would be an agreement among real people that you would write this agreement. It would just be informed by the other principles and the other starting points.
Well, and also, to be honest, I think this is the sort of thing that would lead a kind of stepping stone to other covenants as well, because you could, let's say, for example, I had my little NAP revolution and we had this kind of peace agreement established. Then you would have, say, different communities, agencies, regulatory bodies, whatever, individuals, all of that. They could all say, okay, yeah, we agree to this, but we agree to the Stephan Kinsella interpretation as outlined in this supplementary document. You know what I mean? So at least then people can kind of make sure that everyone knows where they stand with regards to our interpretations of this principle, even though we're all on the same page of the basic understanding.
Yeah, not to get too legalistic, because I think this stuff's interesting. But but for example, there are ways of doing this stuff. Like as an example, I'm in a couple weeks. I'm going to Prospera. You know what Prospera is? It's the thing in Roatan in Honduras. The Free Cities meeting is having their annual meeting there, but it's in Roatan in Prospera, which is one of these island. It's just an enclave within this thing that Honduras set up a few years ago. They allow basically free areas to exist within. They can't have drug trafficking and stuff that Honduras has agreed to in international treaties. They can't do certain things, but basically there's no taxes. It's up to them to do it. So it's like there's not even a tax, but there's like a 2.5% administrative fee you have to pay, but it's all contractual. But in that agreement, they just have common law. But I think they say something like common law as elaborated in the restatements of the law, which is a really good private law, non-legislated American project that codifies and restates the common law principles developed over decades and centuries. But then they say they have the exceptions. They'll say like, we hereby adopt the restatement of the law second of contracts, except for provisions A, B, and C. We don't agree with those because they're too statist. So like you could actually carve out, or you could do what I say and just say, we adopt the restatement of the law to the extent that it's not incompatible with the universal statement of principles. Like, so there's different ways you could draft it, but it would be part of an agreement. And I think you're envisioning an actual agreement people might consider signing up to if they had a free area they could practice it in. You know, the thing that I wrote, so the Constitution of Liberland, the problem I had with it was I was like, well, you're writing this constitution to set up a state that governs this island, which is unowned, but you're sort of claiming ownership of it just by claiming, like the whole thing was just, it wasn't clear who I was writing it for. And it wasn't even an agreement. It was just a declaration of the governing principles of a government that claims to run this island that's claimed to be owned by a guy named Vitt. I mean, like it was all, that's why I had a problem with it. But when I wrote my principles, like I said, I did it because Max wanted to present it to these tribesmen on this kind of deserted area of Africa that he's hoping to get something going there. But he wanted me to put signature lines at the bottom where they could sign it. Like, and I don't care if you add a signature line, that's fine. And you could, it's not written as an agreement, but signing your name to it shows that these are the principles you're willing to live by. And that's how you get a free society going. You could make it more formal and elaborate like you're doing. Like, now I would imagine what you would do instead is mine would not be signed. It would just be these principles, which is a codification of our principles and maybe the supplementary, but it's a body of just written documents that explain things. And then in your agreement, if you're envisioning people signing it, then people sign it somehow. And then by reference, it adopts these principles. I mean, L. Neil Smith did this. You've heard of L. Neil Smith, I'm sure, the science fiction writer. He wrote, he was a libertarian science fiction writer. He died a few years ago, but he wrote three great novels. One's called The Probability Broach. One's called The Gallatin Divergence. They're alternate histories of the U.S. But anyway, he wrote this thing called The Covenant of Unanimous Consent. And he would advertise this thing in libertarian magazines like in the 70s and the 80s. And you were supposed to print it out and sign and send it in. And he would put your name on this. It's sort of like the Mormons, how they identify people's souls or something. I don't know, or they save them or something. But, it was a kind of a crude idea of trying to form. You should look into this because this was like an early version of what you're thinking of. It's called the
what's the guy?
I've got some L. Neil Smith. It's called the Covenant of Unanimous Consent, and he had people. You could print it out. It was like a little constitution
That sounds
sort of
familiar. Covenant of Unanimous Consent sounds familiar.
And you were supposed to sign it and send it in somewhere. And it was not clear what the purpose was. Like I said, it was a hybrid of a constitution and a contract and a statement of principles. That's why when I did mine, I just said, I'm going to write the statement of principles and then they can be used creatively by others in some kind of way. And we'll see. But, I was distinguishing the different roles, trying to be clear about what we're doing. Here's what we believe. Here's what most of us believe. here's more elaborate ways you could apply that. And here's some working codes in the wall that are a little bit statist, but overall they're pretty good. And they could be guides to start from, like the Restatement or the Uniform Commercial Code or the Louisiana Civil Code, something like that. And then you could have an overarching umbrella agreement. Like I say, this starts getting a little legalistic in a way, but there's no way we're around that. You have to have a conceptual understanding of how these parts fit together.
Yeah, no, I agree. And I mean, I know we've got to wrap up now, but I'll finish it off by saying, and I'm looking forward to speaking with you again about this, but that is why I was so keen to speak to you about the Universal Principles of Liberty, because even though it may not have been your intent when you were writing it for this to be like a foundation for law or anything like that, but with regards to my own work, as I say, it was very important for me to help people visualize what I'm talking about by showing precedents, saying, well, look, we have law established through peace agreements, international law, merchant law, these are all examples of it, but also to show them the non-aggression principle articulated into the form of an agreement was also very important. And although you've written a lot of great books and done a lot of great work and contributions to libertarianism, but I think this might even be your most important contribution in the sense of providing this, because it's so important for people to visualize something, to be able to see, and the one thing that the Universal Principles of Liberty provides is that is the NAP articulated into an agreement. And I think with the supplementary material as well, giving that little bit of extra depth and clarity in a way, I think even if it on its own is not enough for law, it's certainly
I think it's and I agree. In a way, it's a culmination. The other stuff is necessary to get there. It was a culmination of that. But yeah, the other stuff was the precursor to something like that. And I envision it could be used in any number of creative. We've never done anything like this before in the world, so I don't know. But I don't know if today is too early, but I'd be curious to see if there's anything in there. Maybe before we talk next time, I'm going on the Tom Woods cruise next week, and I might have time on the boat to do it, to talk if I have good internet. We'll see. And Adam Heyman is going to be on that boat too. But I'd be curious to see if there's anything in the principles as they're written now, anything you think is wrong or should be corrected, anything that is a bright line thing that's obviously a libertarian principle that should have been included, that's also general. You know what I mean? I'm curious if you think there are any things that are wrong in it or that should have been included. I mean, there are things that should have been included, but it's just too general for that. They shouldn't be in there. But that are general and abstract, but also they're missing from it. That should be in there. That they're bright line enough not to have any dispute over them anymore.
Well, I mean, I'll certainly have a closer look at that. But I mean, from when I looked at it before, my first impression was not so much that there was anything wrong with it, but really just, at least for the purposes that I wanted to apply, that there was just a bit missing with regard to these things like IP and abortion and stuff. I think there needs to be a certain degree of extra clarity, just for my purposes. And like I say, I understand why it's not included, for what you were creating. But I do think that supplementary material would be very important for the sort of purposes that I would want to kind of employ. And one final thing, just to kind of round off this conversation, and like I say, I'm very much looking forward to having a part 2. So I think this is a good example of how a lot of our work can really synergize. I mean, I had a conversation with Patrick Smith a couple of weeks ago, who I know you know, and we were talking about his anti-subjectivism manifesto, and he was reading out about the kind of the choice he was presenting. I don't know if you're familiar with that, but I'll put a link in that as well. But he was kind of presenting the kind of choice that he was presenting about, look, we've got a choice. We can live the law of jungle, or we can live as civilized people, and that's where we invoke things like ownership and rights and concepts like that. And then obviously if we do that, we want to apply it consistently. And as he was reading it out, I was like, that's almost a perfect precursor for me to then present the Nations of Sanity project as the peace agreement. And then I immediately then thought of your Universal Principles of Liberty, which is a perfect example of that agreement articulated. And I just feel like all these different contributions can really be put together to present a beautiful path to liberty, which doesn't guarantee
don't disagree
it, but
don't disagree. I think synergy, of course, that's how we learn. We talk to each other, we learn, we build on each other's ideas. They breed with each other. There could be synergy. All right. Well, let's talk again, and I'll let you know what my schedule is like in the upcoming weeks pretty soon.
Yeah, okay. And in the meantime, I'll have a good look at Universal Principles of Liberty with that request in mind and really think about anything else I can give you with regards to feedback. But at the moment, it's really just a case of I didn't really see much I disagree with. It was more just a case of saying I need a bit more here and there for the purposes that I want to apply. But I think your supplementary material would go a long way to fulfill a lot of those missing pieces.
Yeah, and I'm just not publishing it yet because it's preliminary, but I don't mind showing it to you where it is when I get to that point. But like I said, I'm doing the annotations first, and then I'll do the supplementary. But I'll be happy to keep you apprised on all that. Maybe even share a back door to it or something. But anyway, we'll talk later about these details offline.
That's great. Excellent. Okay. Well.
Okay.
Once again, really appreciate you taking the time, Stephan. Thanks everyone for
happy to do it. All right. Have a good weekend.
And you, mate. Take care.